Hello friends, I am Dr. G.K. Goswami and you are watching our show. Today we are going to discuss a very important topic, bias. We all are aware that bias is almost an integral part of our day-to-day life, particularly in decision making. Nobody can say that I have no bias in my opinion making. So how bias influence our decision is very important, because bias actually establish preconceived notion. It brings illogical to our thinking. It is very injurious to judicial decision making. So if we understand in detail about different kind of bias, how it impacts our decision making process, then probably we can minimize the impact of bias in our working. I don't think that anybody can completely wipe out bias from his working style, but certainly after having the knowledge of bias, we can minimize the impact. So let's start, friends. Biases in decision making, as I have already mentioned. So what is bias? Bias is any kind of prejudice, partially or preconceived notion in our decision making. So bias is directly related to preconceived notion. We actually think something different illogically before taking a decision. It threatens fairness. So the major problem, as I mentioned about law. Law has three ingredients. One is just, reasonable and fair. So fairness, transparency, objectivity in decision making is the hallmark. And if we have bias in our mind, the decision cannot be fair. So it is very pertinent that we must understand bias in more significant and wider manner. Bias cloud by personal belief, stereotype or different type of interest. It undermines principle of natural justice, especially nemo judex causa sua. One cannot be judged in his own cause. While we were discussing natural justice principles, that time we have discussed in detail that you cannot be judged in your own cause. Nemo judex sua causa. Now let us see different type of bias. So bias can be defined as we have defined already, but the typology may be different. So there are various methods of classifying biases, but here for simplification, I have tried to divide bias in two broad categories. One is the judicial bias and another is cognitive or psychological bias. Although they are intertwined, you cannot completely compartmentalize this classification, but for the ease of understanding, I have tried to classify in two sectors as I mentioned. So let's see. Type 1, the judicial or legal bias. And virtually speaking, in the decision making, particularly in the court, there are three kinds of judicial biases. One is actual, which you can apparently identify. The another one is apparent, which seems to happen. That is apparent. But this is likely to happen, then it is presumptive. So these are three categories. One actual, another apparent, and third is presumptory. So let us see how they operate in our decision making. Actual means really proven prejudice of the decision maker. Here it may be judge. The example is a judge may openly criticize the party based on various factors, maybe race, maybe religion, maybe region, maybe some gender or various other parameters. If we see the live case, the case was R versus Vo. This was decided in 2000, where Lord Hepburn was found to have undisclosed links to Amnesty International, which was a party to this case. So here it was directly bias was visible because it was actual bias. The apparent bias, where a situation where reasonable person might suspect bias, even if it is not there. So reasonable person can suspect that there is a likelihood of happening such type of biased decision. The example may be a judge hearing a case involving a company in which he has his own interest. The live case is Dime versus Grand Junction Canal of 1852, where the Lord Chancellor decision was set aside because he had the share in the company, which was party to the list. Then presumptive bias. Bias is presumed by law due to direct interest. Judge is related to the party. In Manaklal versus Premchand Singhvi in India in 1957, domestic inquiry was found tainted due to the bias of counsel appearing as an adjudicator. So these are three types of bias we have understood in judicial system. The another one is cognitive. Cognitive means, friends, your thing related to your brain, your thinking, and it is more psychological of nature. So cognitive bias are of different type. Let's see how they operate, and I think we all suffer with this syndrome of confirmation bias. Generally, see, if in our day-to-day talk, suppose there is rain outside, we generally say, oh, yesterday I have already said that tomorrow there will be rain, right? So like the confirmatory bias, generally we try to act like forecast person, as if we can foretell the event. So that is confirmatory bias. Many times in forensic science also, confirmatory bias, like without believing or without going to the scientific analysis, sometimes we take decision. In the segment of forensic biases, we will take this confirmatory bias in more detail. Confirmatory bias, if we see in police department, police investigator collect evidence proving his theory. So normally when a policeman collect the evidence from the scene of crime, generally they collect incriminating evidence because they want to prove crime, irrespective sometime whether the person is really a culprit or not. So that is also a confirmatory bias. Confirmatory here is because someone has taken a decision or taken a mindset and now he is trying to prove it, and that is confirmatory bias. So you take a decision prior to collect evidence or to prove it otherwise. Then anchoring bias, it is over-reliance on the first piece of information, and plea bargain is the best example. In plea bargain actually the anchoring bias do operate. Affinity bias, sometimes we have affinity with the party or the other group, like based on caste, creed, gender, your various other affinity factors may be there, and then that affinity actually operate in your decision making. Many times the decisions are influenced by caste, religion, language, your race sometime, your educational background, various factors may affect this. The halo bias, overall impression sway judgment on specific trait. Halo effect, very well you can understand that suppose there is a film celebrity, and if they go for any courtroom proceeding or something, so they get advantage of their popularity. Likewise, those people who are very much articulated in the courtroom or they have known acumen in the field, so they get advantage despite the merit of the case. That is called halo effect. The recency bias. Sometimes we believe on the recent events. Sometimes, say for example, a person is caught committing a crime in the recent past. In his previous case, the judge or the adjudicator may take decision against him considering that he is found allegedly involved in that particular type of crime in a recent past. Then stereotype. I think we are well aware what is stereotype. We have so many things with various creed. Sometimes we talk about people like, say for example, a lot of folks, lot of folklore and many other things are directly related to stereotype. Stereotyping is making general assumption about people or group. Sometimes a particular caste, sometimes a particular religious man with their attire, and there may be racial or faith or caste based profiling by police. So these are all stereotype kind of decision making which actually adversely impact the fairness in decision making. Now, yeah. So, the another scenario of bias from life examples. See, media bias. We all are well aware that many a times media, particularly media trial, also influence decision making, and not only common man's decision making but even in the court. And there are hundreds and hundreds cases reported across globe where media is responsible for biased decision making. Then community bias. Local body authority showing favor to a particular group of people. That is community bias. Because community are divided, and if in panchayat or any type of decision making body, they also get influenced by their community affinity. So this community is basically related to affinity bias. Then employer bias. Sometimes the employer has some favor, maybe friend or maybe some other region, to give some promotions, some monetary benefit or any other thing. So in their decision making in the organization, the employee face the discrimination based on bias by the employer. Then bias in forensic investigation, we will talk in little detail, but there are hundreds and hundred cases reported across globe where various type of bias have impacted the forensic reporting, and which is very serious affair, because forensic reports are taken very seriously in the courtroom, and if the forensic opinion is conditioned upon various biases, then definitely miscarriage of justice is bound to happen. So that's very, very important part, friends. And this case is very important in India. K. An Bajagan versus State of Karnataka in 2015, where transfer of trial due to reasonable apprehension of bias. So there are live cases. I have mentioned various cases in this column. Those who are interested to study further, they can get these slides. I can share with them. You can write those who are interested in the chat box. We will provide you the content. Now let us see the judicial bias, judicial observation on bias. Different type of cases we can see. In India, I have identified 3 important cases, although there are series of cases we can cite, but considering the limit of the time, the paucity of time, I have restricted myself to 3 cases, right from 1957 to 2001. In Manaklal versus Dr. Premchand Singhvi, a lawyer who represented opposite party was appointed as inquiry officer in a disciplinary proceeding against the same person. The principle of nemo judex causa sua was implied because the apprehension of bias to vitiate proceeding was observed, and Supreme Court set aside that inquiry. In AK Karai Park versus Union of India in 1969, you will surprise that for the selection board, the member was himself a candidate to get selection. You know, that's the extreme case probably, where selection board member was himself a candidate. So that was against the principle of natural justice, and the selection was quest. The State of Punjab versus V.K. Khanna in 2001, the administrative inquiry manipulated by biased officer. Bias can vitiate proceeding irrespective of criminal or civil. That means bias impact both civil proceedings as well as criminal proceedings, because in both matters you have to take a decision which should be justified, which should be fair, which should be transparent, which should be legal. So fairness is always challenged if there is biasness. If we see in United Kingdom, friends, there are cases like Dimes versus Grand Junction of 1852. In this case, Lord Chancellor decided a case despite having share in the company. So he was directly linked with the proceed of the company. And it was again nemo judex sua causa. In R versus Wo, Lord Hoffman was director of Amnesty International, and that is why this decision was also quashed. In R versus Sussex Justices, clerk to justice was from the law firm acting for the prosecution. Justice not only be done, it should be seen to be done. And based on this principle, in this case of R versus Sussex Justices, the judgment was quashed. Conviction was quashed. In US, friends, Tome versus Ohio in 1927, mayor acting as a judge and received part of fine. So again, he was having his interest. Nemo judex causa sua. So the judgment was quashed. In Capleton versus M.Sc Coal Company in 2009, elected judge received massive election campaign donation, and it was considered that if some party is funding the election, certainly he will get benefit later, and that is why this case was found to suffer bias and the decision was quashed. In Shepard versus Maxwell, excess media publicity created community bias, and that is why, again, community bias by media, it is a very, very prominent, and it continues everywhere. I think you might be aware that how media influence the decision and the mindset, opinion of the people. In South Africa, there are few cases. President of Republic of South Asia versus SA Rugby Football Union, allegation that Constitutional Court judge has expressed preliminary views, and that is why region apprehension of bias was not real. It was just merely a conjecture, and hence there was no remedy. In Bernstein, judge has previous role as counsel. Mere prior, this is again a very important thing, that suppose you are a lawyer, and earlier you have dealt the case of the opposite party where you are appearing now. So your previous handling the case of the opposite party does not mean that you are a bias, because you are a professional. So here this biasness was not being proved. In Australia, Ibner versus official trustee in bankruptcy, the judge has share in bank which was a party. Again, it was the same fate that nemo judex causa sua, and the judgment was quest. In Live Say versus New South Wales Bar Association, member of tribunal had previous involvement with the case and impartially must be preserved, and it was disqualification was upheld. Now, nature of bias in forensic domain. Friends, forensic science is very, very important for decision making, particularly in the courtroom. And forensic evidence are vital both for criminal matters as well as civil matters. And as you know, that forensic report is an opinion, and opinion have larger chance of different type of bias suffered many a times. And these type of biases have been reported across globe, including US. I had opportunity to study in detail the forensic bias, and I had met a lot of people who were being involved in such type of cases, and based on that I have prepared few slides, although this topic is again very wide, but I am trying to give in a nutshell. Bias in forensics may be cautious or non-cautious. Many times bias, we are all suffer bias because of our unconscious decision making. We think that we are neutral, we are transparent, but in actual practice we suffer from different kind of bias. Forensic bias refer to situation where a forensic expert opinion, finding or testimony are either unfairly influenced by extraneous factors, like collection of incriminating evidence by prosecution or by police. I am a police officer, I can definitely look back that this statement seems very true, because police make their story, and always you start when there is a blind case with various kind of possibility, and slowly and gradually when you move ahead, collect evidence, then you narrow down, and once you reach to that, so your mind becomes to collect those evidence which are proving the police story or prosecution story. And that is why the inherently, unknowingly sometime, the police start collecting incriminating evidence and ignoring exculpatory evidence. It impacts integrity of evidence, because if forensic report suffers biasness, then integrity of evidence is not acceptable. It misleads court to deliver a judgment loaded with miscarriage of justice. It is miscarriage of justice of two types here. Possibility may be wrongful conviction of innocent person or wrongful acquittal of guilty person. So either way, it is very bad to the society. So bias directly impacts the decision, and miscarriage of justice is the outcome of these type of biases impacting the forensic opinion making. Now let us see what kind of biases are there. Although what we have discussed already, by and large, they are observed in forensic decision making, but just for the ease, I have tried to give another slides or some more time on forensic bias. As I mentioned, cognitive bias. Cognitive bias, sometimes those people who are quite experienced, they unknowingly think that what they are deciding is perfect, and that is cognitive bias. Our brain look at everything what we have done previous. So we start connecting the present with the past, and we think, oh, I have done so much of cases. I have taken so much of decision, I have so much long experience, how can I be wrong? And this case belongs to that case. So there are chances of finding patterns and confirmation. So we find patterns, oh, the same type of things were happening in that particular case, similar thing is there. Even there are similarities in various cases, but they are not identical. Understand difference between similar and identical. No two cases can be identical, there may be similarity. So be always neutral, objective when you take decision, especially my request to those who are involved in evidencing. Focus on opinion that support what experts believe rather than science. So they overpower science sometimes. They feel, oh, I have done hundreds of cases, thousands of cases, how can I be wrong? So they overlook the scientific observation and they impose their opinion, which may not be scientific, based on their past experience, so-called. Then contextual bias. Sometimes context, we feel, oh, this person has confessed the crime. So then DNA will match, fingerprinting will match. So these type of ulterior, decision making by extraneous factor. We are not looking what science says. We see the environmental factors, contextual factors. So these contextual factors sometimes take you away from the truth, from the reality, and vitiate the decision making. The extra knowledge of crime, I always say that when you are matching the sample, why you need some external information? External information are required only when you are converting opinion into evidence. And I always advocate that the expert provide you expert opinion. It is the duty of the investigator or the prosecutor to convert that opinion into credible evidence. So this dichotomy is very important to understand. We have taken various classes on this point. Here it is not apt to deliberate further, but again I repeat that forensic expert provide forensic opinion. It is the duty of the prosecution side to convert that opinion into credible evidence. That's the point we have to learn here. Then expectational bias. You see, many a times the expert or the decision maker is under somebody's influence. Many times it is alleged that forensic experts work under prosecution or police. So they have expectational bias because their senior, their boss, they may like a particular type of reporting, and that may be suffering from bias of expectation. In Melendez-Diaz versus Massachusetts in 2009, the Supreme Court hold that experts are not machines. So defendant has right to cross-examine them to expose potential bias. This is a very, very important judgment. And on the similar line, in year 2022, the Honorable Supreme Court of India in P. Punnuswamy of Kerala, P. Punnuswamy versus State of Kerala. So in this case, friends, the Supreme Court said that please call the expert for cross-examination to explore truth behind their reports. They are not machine, what Melendez-Diaz said long back in 2009. So now it is a trend in India also that forensic experts are being called for cross-examination by the defense lawyer. What law says earlier in 273 of CRPC, alternatively 329 of BNSS. It is written that the expert will not be called for cross-examination until and unless the magistrate demands so for some clarification. In my opinion, for the purpose of fair trial, cross-examination is the right of the defense. So, it is very, very apt to say that the experts should be called for cross-examination as mentioned in Dias case of United States and in Punnuswamy case or Anokhilal case. There are several cases in India also, and now the trend is going to call forensic expert to the courtroom during trial for facing cross-examination by the defense to find truth behind their opinion. And I think this is a very, very important point to be noticed over here. Now the type of bias in forensic continues. Motivational bias, yes, that also impact. Many times, not only forensic expert, but we all do something for getting some reward, getting some recognition, getting some pat by our seniors. And same happen in the forensic experts also. And I will give you example of Massachusetts, where a lady expert who provide huge number of expert opinion on drugs in favor of prosecution. Annie Dukhan. Her name was Annie Dukhan. And she was prosecuted later. She was awarded some imprisonment. So, she was actually being rewarded. All kind of praise she got. So, we all suffer to get recognition by our seniors, by our society, by our media and all. So, I think that is very, very important in decision making. We should not be the victim of such type of biases in our decision making. Then procedural bias. Many times we feel and we bypass various procedural protocol in decision making, and especially in forensic science. In forensic science, procedures are as important as the scientific technique or principle is. Until unless scientific principles are coupled with the righteous and objective procedural protocols, the opinion cannot be acceptable. And such procedural defective opinion are the root cause for miscarriage of justice. Various people have been wrongly convicted. Various accused who were really guilty, they have been acquitted. So such type of bias in procedures affect the system very adversely. Then selection bias. We are selective in our collection of evidence. As I mentioned that police particularly suffer with this syndrome to collect incriminating evidence mostly and avoiding collecting exculpatory evidence which are in favor of the accused. I have already mentioned various things like confirmation bias, then contextual bias, overclaiming expertise. Confirmation bias, as I mentioned, especially with those who are much experienced, they feel, oh, I know. So the confirmatory bias decisions in forensic science are again challenged. Then contextual bias. Many times, if the forensic expert know that the accused has confessed the guilt, then they try also to match DNA, the partial fingerprint, and various other techniques which they are reporting. Then overclaiming. Overclaiming is again a very, very big problem and a bias. Most of the time I have also heard talking the forensic experts saying that their technique is 100% accurate. My dear friends, not even DNA is 100% accurate because it is an opinion. opinion cannot be 100%. And there are procedural biases. There are error rates. So every technique has some error rate. So if any report or any expert is claiming 100%, having zero rate of error, then that report is suffering from bias and is not tenable, not acceptable, not admissible. So be very careful that your overstatement, say for example, in bite mark, my dear friends, is junk science. It is already proven fact. So bite mark cannot be a scientifically proven evidence. And there are so many examples, and very famous example in Virginia in United States, Keith Allen Harvard, who was wrongly convicted based on flawed by mark, and later he was exonerated. During my Fulbright fellowship, I had opportunity to meet multiple such victims who were being wrongly convicted and were languishing in jail for very, very long time. Multiple decades they were there. So when you listen their story, then you realize that how, brutally sometime the criminal system operate, and they are not being heard properly, and various type of bias do operate to wrongly convict them. The tunnel vision. Sometimes we have a very, very limited, focus of our decision making. That is called tunnel vision. Police lab exclude alternative suspect. We say, no, this is the criminal. We do not look others. Sometimes our vision is so focused, and that is wrongly focused. The very critical example of this tunnel vision is Driscoll versus the Queen this is a Canada case, where hair comparison overrated and later it was discredited. Then lab bias. State-run lab tied too closely with prosecution conflict of interest, as I have already mentioned. And Houston Police Crime Lab scandal, very famous. I visited this lab personally in 2022 as Fulbright Fellow, and the director is a good friend, Peter Stout. I spent a couple of days with him and in his lab, and I heard the scandal from the horse's mouth, and it was phenomenal learning over there how the forensic opinion can be manipulated, how the corrupt practices can enter into it. So this case, those who are interested can study in detail. Lot of material are available on internet platforms. Then dry labbing. As I mentioned about Annie Dukhan, this case is very prominent. Friends, what is dry labbing? Dry labbing means producing a report, producing an opinion without actually conducting the test. And this lady, as I mentioned, she was very fond of supporting prosecution. She was giving very rapid or you can say very rocket speed reporting. Suppose a genuine forensic expert provide 5 reports in a particular time, she will produce at least 5 times in the same time period. Ultimately, her mischief was identified and she was prosecuted and being convicted. The dry labbing means that producing report without conducting the actual test in the laboratory. How can you believe? But this is the gross reality. These things have happened. And when there was COVID, probably many of us have heard this type of dry labbing, that without conducting the test of COVID, the reports being prepared by various diagnostic centers. So this is not very new in forensic science also. So in various decision making, this dry labbing means without observing the due process, the decision is being taken. Now the concluding remarks. We are reaching to our conclusion, friends. These are the takeaways, and this is a light slide. Bias influence judicial, administrative and quasi-judicial decision making. So bias is integral part of our life, as I mentioned in the beginning itself. We have to reduce it, we have to minimize it as much as possible. I know we all are aware that we cannot completely divest bias from our decision making. It exists, but we should minimize. And today we learnt about it, and I hope many of you will reconsider that how badly or how better we are while we are taking decision and how the bias impact our decision making. It also impacts day-to-day life. As I mentioned, it is not only courtroom decision making, it is day-to-day life means problem. It may be affecting decisions consciously or subconsciously. It is reasonable apprehension of bias raise doubt or decision, and it caused mistrust. Basically, the lack of trust it creates at the individual level. It may be in the family also. It may be in any organization. It may be any region. It may be any state. It may be any country. For that matter, bias is a very, very challenging affair in our life. So at the end, I say that bias impacts the rule of law. Because if we suffer, our decisions suffer from bias of various kinds, that we cannot implement rule of law in true sense. And rule of law, my friend, is the mother of justice. So believe me that if we want perfect justice, we have to get rid of various kinds of bias. I understand it may not be possible 100%, but to the maximum possible manner, we should reduce or minimize the impact of bias from our life. Thank you very much. Once again, nearly around 45 minutes you were with us, and I assure you that we shall discuss various topics which are useful for our day-to-day life, for the lawyers, for the judges, for various students to undergo the competitive exams. It may be very good for you, for civil service aspirants writing in your ethics paper, because bias actually, you can quote so many examples what I spoke you today, and I think these type of anecdotes, these type of learnings can impact your discussions, your argumentation in a very valid and empathetic manner. Thank you very much once again. Be with us, share our channel, subscribe it, that is my humble request, and write your opinion in the chat box. We shall respond to you. Those who are interested to get the PPT, you please write down in the chat box. I will share with you. You can send it your email. Through email also I will provide you. I once again